Hello, students. This is Mike Lilly. The class is Business Law, Spring 2019 semester. This is the 25th and last live stream lecture this semester. I hope you all don't mind the background here of my messy office, since I'm recording this lecture here in my office instead of a classroom setting. As spoken about earlier, since I was not able to give you a live, couldn't meet the live class because of previous commitments. So today's lecture basically is to finish up some brief discussions about bankruptcy, and also to allow you all brief what to expect on the final exam on this class, and so that I can finish up properly the final test in this class. And by the way, it is it's the last test we have in this class, is scheduled for 10 o'clock Tuesday, excuse me, I want to make sure I'm right. 10 o'clock Tuesday, May the 7th, in the classroom. There are some students which whom a take-home test has already been forwarded. And I am hoping that the rest of those, I know there's at least 3 more students or more who've yet to take the third test in this class, and we'll see about those. I'll probably get those graded tomorrow, because I'm still hoping we'll have some more people come in and take it. On Tuesday, I will return those test grades to you, as well as those who've submitted theirs by email or other mechanisms. So let's talk more about bankruptcy. Last class period, we talked about the history of bankruptcy, the fact that under the United States Constitution, Congress itself given specific power to create all bankruptcy laws in this country. And indeed, important enough that I'm busy, I'm looking here at the textbook, so pardon me. Important enough that under Section 8 of Article 2, bankruptcy rights granted exclusively to Congress were more important than declaring war and all sorts of things. And it is the third paragraph in Section 8 which says to establish uniform rule of naturalization, uniform laws on the subject of bankruptcies throughout the United States. And that's before the war powers or the creation of the federal courts or anything else. So bankruptcy was extremely important to our founding fathers. And so as a result of that, therefore, it has always been and will always remain a special federal remedy only, not a remedy for other states. So we also talked about the basic structure of the U.S. Bankruptcy Code, which is, we've already commented on, is a special section of the, I think it's what, Section 11 of the U.S. Code, where the Bankruptcy Code is situated. And it is the U.S. Bankruptcy Code. Again, we're finishing up our chapter 32 on bankruptcy, which is on page 374 in your text. Now again, please excuse the messy background. This is my messy office. I make no pretenses or claims that it is not, which is one reason why I don't do very many lectures from in here. Anyway, so there are at least 5 or 6 different types of bankruptcies under the Federal Bankruptcy Act, and they are named by the chapters in the Bankruptcy Code where these forms of bankruptcy are. You can look in your text over here on page 376 to see the 6 types of bankruptcies that are listed. And again, our principal lecture and what you're responsible for on this test is discussions on Chapter 7, 13, and 11. I briefly mentioned Chapter 12 because Chapter 12 involves the family farm bankruptcies. And again, as I've said, basically speaking, we don't have a lot of Chapter 12 filings here in southern West Virginia, although we could. Pardon me, that's my iced coffee from this morning to keep me awake. So, we pretty much discussed most of the material in this chapter about Chapter 7, exemptions, the automatic stay, what's dischargeable and what's not dischargeable under the Bankruptcy Act, and certain other things. So let's fast forward again to Chapter 13, so-called Chapter 13 composition agreement. It's officially titled Reorganization of Individuals' Debts. As I've said before, a Chapter 13 essentially is a federal composition agreement. And the material on the text here starts on 738 in your text. Again, where it talks about the concept of Chapter 13, which essentially is aimed at allowing a debtor to pay off their creditors by, one, holding up any attempts by the creditors to do any kind of collection procedures. The debtor is allowed to remain in possession of all of their secure transactions, and the debtor is also allowed, again, to make pretty much reduced payments on those obligations. And the reason the payments are reduced is because the bankruptcy court itself sets what the monthly payments are to be. It deducts those payments from a person's paycheck automatically. Or I forget to mention that it actually can be used for persons on Social Security income. Can be deducted from your Social Security check automatically. But there must be some source of income coming into an individual in order for Chapter 13 to be implemented. And quite frankly, Chapter 13 is said before, is not for everyone. You have to have a basic source of income enough to pay off these obligations. Again, Chapter 13 plans are anywhere from 36 to 60 months, and that's by the statute. Initially, most are 36 months. That's a 3-year plan. Although I'm told now that the odds are kind of shifted to 48 months. In other words, a 4-year plan. Bankruptcy judge really doesn't like to do more than that because it ties up a person's income and assets significantly longer. I did forget about the fact that Chapter 13 is basically aimed at and looking at Personal property only. Real estate is not necessarily covered by a Chapter 13 plan, although the bankruptcy judge is entitled to take a look at it. Okay, a Chapter 13 is only for individuals. It's not for businesses or anything else. Okay. There is an income requirement, again, regular income. And the text points out you have to owe less than $383,000, basically. I'm sorry, few people are going to have a significant enough income to be able to make a payment on $300,000. So debt is just not going to happen. Okay. There is a so-called repayment plan. The creditors, by the way, do have to come into the courtroom and file various claims. There is the ability to overturn any secured creditors' plans or profit-making situations, and once again comes into play. I'm also honest that because a Chapter 13 plan does not take into effect real estate, so there was a mortgage on someone's home, then that makes, I'm sorry, I have to sit back a bit, makes some limitations problematic, I think, about people who have great big house payments and then have to make a fairly large payment under a Chapter 13 plan. So Chapter 13 plan is not for everybody. I don't speculate that it is. And the number of 13 plans, as your text points out, actually filed and gone through within this country is somewhat limited. I might also add that one of the things about a Chapter 13 is that if the debtor who files the plan runs into more significant financial issues, they can then return or refresh the plan. Excuse me, they can then, not return or refresh, they can then convert the plan into a Chapter 7 liquidation with a small filing fee. In former times, it was most common that we would see these filing fees, most people filing 13s converted into a Chapter 7, although not necessarily so these days. Because quite honest, the courts are very, very strict now about allowing a 13 reorganization plan to go through, given the assets of the debtor. And they look very carefully at those assets, very carefully at all of that stuff regarding whether or not it takes place. Now, let's talk about Chapter 11, which is the second most common form of bankruptcy file. A Chapter 11 is also called a business reorganization plan. In some ways, it's similar to a Chapter 13, except a Chapter 11 is only available to businesses. Individuals cannot file a Chapter 11 unless they are conducting their business under some form of organization, such as corporation, LLC partnership, limited liability corporation, limited liability partnership, or some of the other types of business organizations. A sole proprietor or a sole owner of a company who simply pays normal average income and has not been set up as a business per se is not necessarily available to have a Chapter 11 plan. Chapter 11 plans, because they do affect business per se, are commonly used honestly, for all sorts of different companies and issues. So let's talk about some of the major Chapter 11 bankruptcies we've seen and some of the other topics that some of these people use in Chapter 11 bankruptcies. First and foremost, a Chapter 11 bankruptcy allows the owner, allows the company to continue operating in business while they attempt to come up with a plan to pay out these things. And therefore, as a result, anytime a company has these financial issues, they're always going to file under Chapter 11. They can continue to still remain in business while trying to see if they can extricate themselves from bankruptcy by finding creditors, payments, or whatever. Odds are that many of you have known or have seen companies that have filed Chapter 11s over the years. One of my best examples has always been Sears Roebuck Kmart Corporation, which has been in bankruptcy at least once. Indeed, Sears Kmart just came out of a second or third filing of Chapter 11. The principal owner of the company, Mr. Lambert, having pledged and paid $5.2 billion into the bankruptcy court to get Sears out of bankruptcy and leave open, I think, about 460 stores in this country. That, of course, is significantly less than it has. And what it's basically amounted to is that Sears has come a long way from almost 2,200 stores to 460. Can they really continue as a business? I don't know. I'm not sure that's true. We'll see. I've had some other major companies that have filed bankruptcy over the years. Your text has as one of the examples General Motors. And so I would make the comment that 2 of the big 3 auto manufacturers here in the United States did end up having to file bankruptcy. That's General Motors and Fiat Chrysler, both of whom were bailed out of the bankruptcy situation by the federal government as a part of its stimulus packaging under President Obama and initiated by President George W. Bush. And so size is not necessarily an issue. I think value-wise, supposedly the largest bankruptcy we've ever had filed was the bankruptcy filed by not Qualcomm, but I'm trying to think. Enron, excuse me. Enron initially was valued at something like $100 billion. By the time of the collapse of the company and bankruptcy, it may have had $2-3 billion in assets if it had that. And again, we've had major bankruptcies among most companies. Give you examples. Another example, Circuit City. Circuit City, one time the largest electronic retailer in the United States. It's not even here anymore. It ended up having to be liquidated and all of its stores closed. Its close competitor, Best Buy, barely escaped filing bankruptcy. And Best Buy is now doing very well, despite the competition from Amazon and other online electronic sellers. Another example, I was trying to think of some that more recent that you might be aware of, Blockbuster Video. There is still a single Blockbuster store here in the United States. It's up in Alaska. At one time, Blockbuster Video, the company that pioneered or really took off with filing DVDs, had over 44,600 stores in the United States. There's only one left. All the rest disappeared into bankruptcy in which they were liquidated. We have seen many, many other companies under Chapter 11 file bankruptcy. Some have made it and some have not. And essentially, the thing that separates, I guess, the sheep from the wolves is what assets, if any, the company has and how busy can they do it. Let's see. Another major bankruptcy already declared, and you probably know about it, is Payless Shoe Company, which filed Chapter 11 last month and closed all 2,200 stores here in the United States. So Payless, again, an example of a company basically which, when it goes into the Chapter 11, it does not intend to continue doing business afterwards. Now, let me make a few comments about another thing about, again, bankruptcy, and that is the ability of Chapter 11 to be used by companies to shield themselves from major issues regarding debt. Okay? One of the chief things that most of us have always thought of is that a company filing bankruptcy has to be insolvent, right, or unable to pay their obligations. But we've had a number of large bankruptcies under Chapter 11 file, mainly for protection against people filing claims. The first major company is the John Mansfield Company, which at the time it filed bankruptcy, was the largest seller and manufacturer of building supplies in the United States. They particularly specialized in asbestos shingling. Along comes scientific evidence regarding the spread of asbestos, okay, and the fact that John Mansfield is soon going to be inundated with thousands and thousands of cases to be filed against them for asbestosis or mesothelioma. I can't even pronounce the name anymore. You'll see a lot of these on your TV shows, filing for lawyers trolling for clients in mesothelioma cases. I think that's right. And again, there are a number of law firms, in fact, in this state, the Siegel Law Firm and some others, who have done a lot of pioneering trial work regarding asbestos cases. John Mansfield was a very profitable company at the time they filed Chapter 11, but they could see the handwriting on the wall. And thus it was as a result of John Mansfield's filing of bankruptcy, a large sum of money was set aside, about $3 billion, which was a lot of money at the time, to pay off future asbestos claims. That $3 billion fund augmented by other individuals, has now grown to about $30 billion. It's a lot of money sitting around somewhere for prospective asbestos claimants to file under. John Mansfield itself, company pretty much collapsed. It's now known as the Mansfield Company. It still has some manufacturing products it makes, but it no longer makes anything with asbestos in it. It's no longer the major manufacturer of roofing or other things of what they used to be. Another major company that filed for under Chapter 11 is Dow Corning. Dow Corning has been and still is the major glass producer in the United States, and makes most of its money selling fiber optic cable, a product which Dow Corning invented. Dow Corning, however, had another sideline, and that is in various medical devices, the most infamous of which is the so-called breast implant, silicone breast implant. And the silicone breast implants, which by the way are still permitted to be used in somewhat limited nature, was something used not just for reconstructive surgery after breast cancer, but it's also was being used a lot for commercial purposes, for breast augmentation and other things. The problem was that a breast implant is nothing more than basically I don't want to say balloon, but basically a filled container, looks like kind of like a balloon filled with liquid silicone. Silicone, of course, being an indestructible chemical, but they leak sometimes. And of course, breast implants are planted under the skin, and there are significant issues about whether or not breast implants had major medical problems. Dow Corning files a Chapter 11 to protect itself from about thousands of women complaining that the breast implants they made leaked and caused significant harm to women in whom they had been surgically implanted. The irony of the case is at the time, we had three competing groups of doctors, one paid by the company, one paid by the bankruptcy court itself, and one paid by the plaintiffs, all of who did extensive research and work on the implants, none of which revealed any significant major physical harm to women who had these ruptured implants in them. They caused scarring in some things, but none of the things that they thought of. Despite that fact, Dow Corning put up, I think, about $1 billion in storage to take care of this situation, and exited from bankruptcy. Dow Corning, which has now been purchased by another company, and the name escapes me, still there, still makes fiber cables. I think it makes the glass for most of our televisions, including this tablet that I have here. And there's a glass, which has the pixels in it. It remains a multi-billion-dollar successful company, but driven to file bankruptcy because of the problems, supposed problems that is with breast implants. Now, breast implants later, excuse me, my voice is starting to go again. Breast implants later would be approved by the FDA for limited use. And it hasn't been in recent weeks that we've had a new warning on the use of breast implants by the FDA. And it looks like the old claims that Dow Corning had to suffer through may very well be coming back once again to haunt any number of women who've had those implants surgically installed. Probably the largest single bankruptcy involving medical devices was a intrauterine birth control device called the Dalcon Shield. The Dalcon Shield kind of looked like a spring, a metal spring, I think it was. I think it was metal, which would surgically install in a woman's uterus as permanent birth control. The problem was that the Dalcon Shield began to be developed with major problems: sterility, uterine cancer, cervical cancer, all of which were coming about as a result of this device being implanted. The company that created the Dalcon Shield files Chapter 11 as a result of over 14,000 tort cases being filed to take care of the company called Merck. No, not Merck. Anyway, the company headquartered at that time in Richmond, Virginia, files Chapter 11 to protect itself from these 14,000 plus claims. There were so many claims being filed and so many threats of claims being filed that we saw on primetime television ads paid for by the company asking women who had the Dalcon Shield either still in them or had been removed to file a claim. There were certain times you could file a claim. Again, I said 14,000 claims. A $3 billion settlement fund set aside for these Dalcon Shield claims. More than that probably still left, but the end result is, again, the largest single medical device recall and issues that I think has ever happened. The company that owned it, A.H. Robbins Company, is then, as a result of the bankruptcy, bought by the Merck Company. I get my names right here. Merck paid into the bankruptcy court $3 billion to cover and handle all of the claims that they thought were going to be filed. So A.H. Robbins, which at the time the case started was among the top 2 or 3 pharma companies here in the United States, goes under as a result of that happening. I would not be surprised if we do not see in the near future Johnson & Johnson, which is again a major drug manufacturer, having to file bankruptcy as a result of the numerous lawsuits involving claims of cervical cancer being caused and other feminine issues being caused by the use of Johnson & Johnson baby powder in pubic areas. I don't know. We've already had the at least one multi-million-dollar suit successfully brought against J&J. And so I guess we're going to have to just see how that works. And by the way, I'm not talking about the Johnson Wax Company. We're talking about, again, the medical company, which makes a number of different products and has many prescription remedies around, but they also make Johnson's baby products. Again, these are issues that are going to come up to play. I'm mentioning these names because I want you to understand that companies can and do file Chapter 11 to protect themselves from plaintiff's claims, which, if they all came into play, would cause the bankruptcy or the liquidation of the company itself. And it's certainly problematic about all of these cases. Let me see. I'm trying to figure out where Chapter 7. Okay, Chapter 7, it starts to be discussed on 392 in your text. And obviously not so. Look, if you will, on 393, where it talks about the largest bankruptcies ever filed under Chapter 11. The first is Lehman Brothers, which, as part of the collapse of the banking institutions in 2008 and the beginning of the recession, had $691 billion in assets. Lehman Brothers, all gone now. WorldCom, $103 billion. General Motors, kind of a piker at only $91 billion. Enron, $65 billion. And of course, Chrysler with $39.3 billion. When you look at those values, collapse of Sears and the escape of Sears with only a $5 billion payment isn't much when we come and take a look at these things. One other thing that Chapter 11 bankruptcies did early on, a company called Continental Airlines, which isn't with us anymore, filed Chapter 11 bankruptcy for one purpose only, to get rid of labor contracts, which they had involved themselves with pilots, mechanics, etc. And in the Continental Airlines case, the U.S. Supreme Court approved that you could file a Chapter 11 and escape from binding labor contractual arrangements between unions and management. Very much protested about. It's pretty much limited now, but some companies are still using Chapter 11 as a way to get out of their what they view as unfair labor situations. Okay. And the leading case on it is mentioned here on 394, the Badisco case, in which under Chapter 11, labor contracts are held to be executory contracts, not completed, and therefore they could be rejected under the filing of a Chapter 11 reorganization. Supposedly after 1984 and 1984 amendments, that particular claim was eliminated, but under the 2005 amendments, there's a possibility, once again, that companies could still attempt to get out of labor contracts as a reason for filing Chapter 11 bankruptcy, but I'm not necessarily seeing that too much. Well, bankruptcy, again, has changed a lot over the years, and I think I want you to understand from this lecture the number of companies that have filed Chapter 11, the amounts of money involved in their filing of Chapter 11, And so I hope that you understand, therefore, that Chapter 11 continues to be a major tool being used by businesses all over the United States when they get into financial concerns. I could go on and name company after company, which has had to file Chapter 11, and we don't see them anymore. I have a suspicion it won't be that much longer that we'll see other large companies having to do the same. And certainly, therefore, you never know. I haven't seen any necessarily on any more major corporate bankruptcies on the horizon, but that doesn't mean that more may not pop up and may not happen in the immediate future. Okay, that's pretty much about most of my discussions on this chapter. The entire chapter is on the test. It is only this chapter on the test. Okay. And it includes everything in the chapter. I haven't left anything out. I would comment, however, that particularly in the older versions of the text, the initial start of it involved an issue regarding General Motors and a large recall of General Motors about ignition switches. And these claims being filed. I can tell you now that since the text is written, the Supreme Court ruled in the case that all claims which would be against General Motors as a result of these ignition switch issues were under the old General Motors, not the new General Motors. And again, you can look in your text and see the difference. And so as a result, therefore, the matter has now been settled, even though still attempts at litigation in the last 3 or 4 years, trying to, again, reinstate the view that claims filed before General Motors files bankruptcy could only be used for whatever assets the old General Motors had rather than the new. Okay, so that's pretty much my discussion of bankruptcy. Let's talk about the final exam. No, there's no study guide filed for the final exam, and the reason for that is pretty simple. It's only one chapter. Everything in the chapter is testable. Nothing is excluded. I will, however, limit the test to 30 questions, combination multiple choice, true, false, and perhaps matching or something else. There will not be an extra credit essay question on this test. I don't think so, unless I choose to add one here in the next couple of days. As a bonus for you all, each question you miss is worth 2 points from 100. That means that every student has a 40-point handicap on this test. If you flunk it, shame on you. And that's all I can say. Okay? So, the test will be given on Scandrons, except for those which have been sent out online or being sent out online to other students. Again, the test is 10 o'clock, Tuesday, May the 7th. And I look forward to seeing all of you then. Now that you've seen my messy office, you know why I don't do too many lectures from here. I hope this has been, you understand, and has been helpful with you, at least on bankruptcy and bankruptcy issues. If you have any real questions before Tuesday, don't hesitate to call me or send me an email about them, and I'll go from there. With that in mind, I'm going to close right now. It's just about 1 o'clock Thursday, May the 2nd, and so we'll see you all live in person here during the exam. I might comment, by the way, it's been a rather pleasant semester with most of y'all. And I hope you've learned something. That's the main key. So I'll see you all Tuesday. And by the way, I still have 3 students who haven't taken the final test, but I'm going to go and grade the final grade, and then we'll look at those tests as they come back. So you can have the grade on this 3rd test by Tuesday morning when you take the final exam. With that in mind, I'm going to close for now. Y'all have a good weekend, and I'll be in touch with you next week. Bye.